sitting on the floor. It's not my usual courtroom. All right, everybody's present here on State of Florida versus Curtis Reeves. Got Mr. Garcia, Ms. Sumner, Mr. Martin for the state, Mr. Escobar. I see Mr. Reeves is present, Mr. Michaels, Mr. Shaw. And are we ready to begin?
We're ready to begin, Your Honor, the defenses.
All right.
I think there's just a couple matters, then we can get started.
All right, what do we need to address first?
Yesterday, as you know, the state filed a response, staff filed a motion in limine to exclude the testimony of Dr. Cohen. It was based not only on lay opinion under 701, but also under 702, and also citing Daubert. As the court's well aware, Friday about 10 o'clock in the morning last Friday, the Florida Supreme Court declined to adopt the Daubert standard as it applies to procedural matters in the state of Florida. It's kind of put us in a little bit of a flux. I don't believe that Dr. Cohen is going to be the first witness. The defense has filed a response to my motion. I have filed a reply to that addressing specifically now the three opinions that they are going to call Dr. Cohen on. What I'd like to do is provide you with a courtesy copy at this point. I also like to file my original pleading, and I would suggest to the court that prior to Dr. Cohen testify this morning, we can just take a short 5-minute break to discuss logistically how we're going to proceed. I think that would help both Mr. Michaels and myself as to our presentation, both in direct and cross, not only for your Honor's benefit, but for the appellant record. Is that acceptable to the court?
That sounds fine. Defense?
Morning, Your Honor. One of the problems here is that we got this motion in limine last week, the week before trial, which forced us to respond. As the court knows, we responded with case law, TAD, and provided the case law, provided some transcripts of some of the depositions. The state, I don't recall the date, but this was a deposition that was taken on June 30th, 2016, and now we're having these issues. I think last time we were here, the court decided that we would have Dr. Cohen testify. The court has both the state's motion in limine, our response, and now the state's reply, which we received sometime after 11 last night. So frankly, Your Honor, I'm not in a position to be able to intelligently argue that. I was up, but I still haven't had an opportunity to research the issues that Mr. Martin broached in that reply. It looks kind of like they're just kind of the same objections as before, and I know that's what he was kind enough to speak to me about. So what I would suggest we proceed as we planned before, have Dr. Cohen testify, and have the court make the decision. The state said, I'm not going to argue anything else. I provided my motion in limine. We're in a similar position. We've argued in our motion that's a response to their motion. And we intend on calling her this afternoon, so certainly there's no issue in addressing it right now. So I would suggest that we proceed as we planned last week, have her testify, and then have the court make the decision after the state has the opportunity to cross-examine her after my direct examination.
Response, Mr. Martin?
I don't think that's anything different than what I suggested to the court. The only nuance is trying to figure out exactly how we're going to proceed procedurally. Now that as of Friday of last week, we're in a little bit of a quandary as far as the gatekeeping standards that the court has to apply. I have some suggestions on that, but I don't think we need to do that now. That's why I suggest if I could just file my response, if we could take a break at the appropriate time, let's talk to logistically how we're going to do this now, since at the time we made that decision, we didn't have the Florida Supreme Court pulling the rug out from under our feet right before we're going to have the hearing. And I don't say that disparagingly, but that's what happened. This place is in a position where we've drafted everything, researched everything, and now we need some court direction from the court. So I don't think anything that I said is any different than what Mr. Michael said. We're just going to need some time with the court to logistically go through it, and then we're going to proceed. That's all.
just gonna take a couple minutes, Judge, and I don't have a problem with that, but if we're gonna be arguing the merits of Dr. Cohen's potential testimony, then that I do have a problem with. So we're just gonna talk about, you know, we'll let her testify, we'll be able to file some legal argument concerning both standards and that sort of thing, then I'm fine with that, so we can do that later on if the court's amenable.
We're gonna just proceed as we had previously indicated. It is a little snag that the Supremes came out with that decision Friday, but we'll deal with it. We're all familiar with both standards, and we can work accordingly. So more than likely, we're going to proceed just as we indicated earlier, and obviously we don't have a jury, so I'm going to be the gatekeeper either way. So there's no sense in us doing Daubert hearings separately. We're just probably going to proceed, and we'll go from there.
May I approach the court with a courtesy copy of my reply?
Yes, you may.
May I file the original with the clerk?
All right, and obviously with the late filing, I haven't had a chance to review it. Same with defenses. I think it was about 600 pages that were filed on Friday that I received late Friday. I did not get through much of it.
Donna, we have also hard copies for you with the TAP cases.
I've got them.
You do?
Yeah, Fran printed them out for me on Friday. And one other housekeeping matter, please be mindful of our stenographer over here. I know sometimes counsel gets rattling off quickly, and she's got a rough job as it is, and it's going to be a long 2 weeks for her, so please be mindful. I may interrupt if you get rolling too quickly, particularly when you're reading stuff. So, all right, Mr. Martin.
Judge, I filed on December 14th of 2016 a state's request for judicial notice of the Florida Administrative Code, specifically Rule 11B-27.00212 regarding the maintenance of an officer's certification. I also filed a request for judicial notice for Florida Administrative Code Rule 11B-27.00212, and I also filed a request for judicial notice on Rule 11B-27.014, and that one deals specifically with the implementation of the Federal Law Enforcement Officer Safety Act of 2004, which is referred to in the Florida Administrative Code. You'll hear a term called an HR 218 license, and basically that's what it is. The significance and the relevance is that Mr. Reeves has an HR 218 license, and therefore he's subject to the firearms qualification pursuant to the Florida Administrative Code as promulgated by the Florida Department of Law Enforcement. And what I'm asking the court at this time is to go ahead and take judicial notice of that administrative code, and it should be in the court file. I have a copy here if you would like to look at it, but I anticipate that maybe even the second witness that I will be using the information in that particular code. Would
Is
you
there
like
any
to?
objection to that?
Your Honor, no objection. He actually specifically cited the Law Enforcement Officer Safety Act of 2004 under stand your ground motion, and we will certainly be addressing that issue because we've contended that he was a retired law enforcement officer, so under the statute. So no objection at all.
Okay, thank you.
All right, so may I then, if the court's going to accept that judicial notice during the cross-examination of the witnesses that I feel is appropriate, subject to any type of relevancy argued, may I go ahead and freely refer to the administrative code in the cross of those individuals?
You may.
Thank you.
All right, are we ready? Does either side wish to have a brief opening?
Your Honor, we do.
There's one other matter that we need to address. I spoke to Mr. Escobar this morning. I think we're in agreement that Ms. Olson is going to be obviously here for proceedings and throughout the entire
Okay.
proceedings.
All right, and Is there any first of all, somebody want to invoke the rule? Thank you, Mr. Garcia.
Yes.
And are there any witnesses present other than Mrs. Olson?
There are, Your Honor.
And
Gentlemen, just wait outside.
is there an agreement as to Mrs. Olson's presence?
There's no objections, Your Honor.
All right, thank you. Okay. Are we ready for a brief opening?
Yes, Your Honor. Mr. Reeves should be granted immunity in this case from criminal prosecution because he reasonably believed that the threat was imminent and that using deadly force was necessary. And in this sort of scenario where we're here on a stand your ground motion, it's unusual in that we're putting the trier of fact into the shoes of the accused. So in order to be able to properly examine this case, to analyze this case, we have to understand what Mr. Reeves was about and what his perception was at the time. This case is about perception. So it's important that we understand who Mr. Reeves is. At the time, he was 71 years old, retired. He was married, and is married. At the time, he was married almost a half a century. His wife was next to him. She was 67 years old. He had 2 children. They're grown now. He was retired from a life of service to the community as a Tampa Police Department police officer. A dedicated public servant who, after he retired from the police department, worked as a director of security for Busch Gardens. He, at Tampa Police Department, and further during his employment at Busch Gardens, Mr. Reeves was trained extensively in the use of force, in the recognition of dangerous situations. He both learned by taking courses and classes and being trained specifically on the job, but he also taught and instructed others to assess dangerous situations and to react accordingly. As a police officer, Mr. Reeves saw firsthand what danger lurked out there. He also saw firsthand that the hand can be as serious, can be a weapon, which can cause serious bodily injury. On the job, he saw broken orbital bones. He saw lacerations caused, broken bones, in other places, concussions, injuries, and death. He taught the people he was responsible for how to assess dangerous situations and how to react accordingly so that they could go home safely every night to their family. He entered Tampa Police Department in 1966, made it to homicide robbery detective by 70. During that time, he also went to school. He graduated from University of Tampa, summa cum laude, in 1976. He was tasked with the responsibility of creating a SWAT team in Tampa, first SWAT team in Tampa. He made captain. And all the while, he was still a family man. His children will tell you that he never brought work home, didn't discuss his job, didn't want to worry them, and was there for them. His son's going to tell you that I'm a police officer. I don't know how my dad found the time to play with me, to coach my soccer league, to do the things he did with me on a daily basis. Retired in 1993 from the police force. All the while, slowly suffering injuries, bad back, feet, shoulder, hands. Started working for Busch Gardens, had to retire after a little over 10 years there due to some problems he was having with his back and other pain management issues. He moved when he retired from Luke's, where they lived for some 37 years, built a house, but not a little retirement house. He built a big house so that he could host family gatherings, because in addition to being a highly trained police officer, he was a family man. He, at one point, decided after retirement that once his daughter had a child, that he wanted to take care of the child, help care for the child. He put his plans to travel to the side to take care of that child, his granddaughter Madison. He would play with her at the house, couldn't get down on the floor with her, so he slowly, Mr. Reeves was seeing himself deteriorate. The things he used to be able to do, woodworking, opening a jar, he couldn't do. Things he wanted to do, get down on the floor and play with his granddaughter, lift her up, he could no longer do. So he has a realization that his body is changing and he's getting old. So that's the man that went to the movie theater on January 13th. Went to the movie with his wife, Vivian. They were going to meet their son, Matthew, there. And when they got there, Matthew wasn't there yet. They went, bought a ticket, got some popcorn to drink, went to their seats. When they got in the theater, they looked for a place that had some seats together because they were expecting their son, and they sat in the back row. The back row in this particular theater was against a wall where the Cine Bistro is. The court's going to be able to see that wall. The court's going to be able to see the seat that Mr. Reeves sat in. The court's going to be able to sit in that seat and see the close proximity to the row in front where Mr. and Mrs. Olson sat. Mrs. Olson sat in front of Mr. Reeves. Mr. Olson was seated in front of Mrs. Reeves. Once the advertisements are over, notice comes on the screen, put away your phones. Mr. Olson is using his phone and the light is shining in Mr. Reeves' eyes. Mr. Reeves leans forward and asks him politely to please put away his phone. The answer he got was a curse-filled response. Mr. Reeves was taken aback by that. And he got up and went to the manager. And you can see, there is a video, and you'll see in the video that when Mr. Reeves gets up, he's moving kind of slowly, using the wall for balance, and he goes to speak to the manager. Thomas Peck is there. He's the manager. He's dealing with another patron, Dawn Marie Simpson. Mr. Reeves waits patiently at the desk, tells Mr. Peck that there's an issue with somebody who won't put away their phone. Very politely, very calmly, walks back to his seat. There's a video, you can see Mr. Reeves walking back to his seat. When Mr. Reeves arrives, as he's passing by, he notices Mr. Olson's put away his phone. So Mr. Reeves apologizes, tells Mr. Olson something to the effect of, I see you put away your phone, I wouldn't have gone to involve management. That provoked a response that nobody could expect, a response that was so far out of the norm, so violent, an eruption where Mr. Olson started to cuss, using the F word. And we know he did because we have several witnesses that are going to come in here and tell the court that he did. There were people in the theater that will say they heard Mr. Olson's voice above the previews. And the previews are loud, and it's dark in there. The court, again, is going to be able to see just how loud the previews are, how dark that theater is, to get some sense of what Mr. Reeves' perception was at that time. You have a movie theater, you have an individual standing up, a 6'4" individual who's younger than Mr. Reeves, standing in front of him, now cursing. Mr. Reeves tries to move back in his seat because now it appears that Mr. Olson is coming over the seat. In the video, you will see that you can see Mr. Olson's head and you can see an arm come into the video. There appears to be something thrown by Mr. Olson. Mr. Reeves tells police after he's arrested there was a blur of something he thought was a phone that hit him in the head. After the incident is over, there's a phone between Mr. Reeves' feet. In the video, frankly, nobody can tell 100% what it is. Mr. Reeves had some shoes on that had some reflectors, but nobody can deny that a phone was found between Mr. Reeves' feet and that Mr. Reeves felt something hit him on the left side of the head. You're going to hear from a witness who's right down the road from Mr. Reeves who's going to say she saw Mr. Olson make a throwing motion when he stood up. You're going to hear another patron who was seated in the row right before Mr. Olson tell the court that he heard Mr. Olson, and only Mr. Olson's voice, loud, using the F word, and it alarmed him to the extent that he was starting to get out of the seat because he thought there was going to be a fight and that he was going to go over there to try to get involved and maybe try to stop a fight. But he didn't hear Mr. Reeves. You'll see in the video there's a second attack. Mr. Reeves in the dark theater sees one hand come at him, sees an object that hits him. A short while later, as the barrage of cuss words continues, Mr. Reeves sees another hand coming forward. We see in the video that it's Mr. Olson grabbing the popcorn bag. Mr. Reeves doesn't know what that is. Mr. Reeves sees a hand coming towards him. Grab the popcorn bag. The hand comes back. And then the hand comes towards him again and mashes the popcorn bag into Mr. Reeves' face. So he's seeing hands come at him several times. That's when Mr. Reeves decides that the only way that he can protect himself, because at this point he's back in his chair because his training tells him that he needs to get as much distance between himself and the attacker as he can. He's leaning back in the chair, and at that point, fearing another attack, pulls his pistol and fires a shot. That shot goes through Mr. Olson's wrist and then through Mrs. Olson's finger and into the chest of Mr. Olson. So what you will see is, you'll see stippling on the hand of Mr. Olson. You'll see some stippling on Mrs. Olson's hand. And so in some way the hands are lined up. Because Mr. Reeves is firing at a slight upward angle, the pathologist will tell you that it's reasonable to put Mr. Olson bending over, thus coming over the seat. Importantly, in that whole sequence, when Mr. Reeves comes back to the theater after going to management, he picks up his popcorn and he sits in his seat. So certainly not the actions of somebody who is spoiling for a fight or doing anything other than apologizing and sitting back in his seat with his popcorn. Olson's behavior terrified Mr. Reeves and terrified his wife who was sitting next to him. After the shooting, Mr. Reeves puts the gun on his lap, show that he's no longer a danger. An off-duty Sumter County deputy comes, gets the firearm. Mr. Reeves is then arrested after practically the entire Pasco County Sheriff's Office responded to the scene. As Mr. Reeves is being let out, he's taken to the car. He gives a couple of interviews to Detective Proctor. So he's cooperative. He's telling them that he thinks he was hit by something, thinks it may have been a phone. We know that Detective Proctor writes the arrest affidavit without ever having stepped foot in the theater. We know that Detective Proctor knew perhaps there was a phone found, but didn't know to whom it belonged on the floor between Mr. Reeves' feet. While Mr. Reeves is out in the car, the technician comes, is going to photograph Mr. Reeves, Susan Miller. She notices there's a red area on his left eye, and so she documents it with a photograph. Interestingly, in this whole thing, Matt Reeves does come to the theater eventually. And when he gets there, he comes around the corner, gets on the landing of the stairs, is looking for his mom and dad, can't see him because it's too dark, so turns around and watches the previews. As he is watching the previews, there's a lull between two previews, and he hears his father in a frightened voice, a voice he never heard before, but recognized his father, saying something to the effect of, "Get out of my face." Soon thereafter, there's a slight delay, but soon thereafter, he hears a shot ring out, and when he does, Matt Reeves is facing the area where Mr. Olson is. He sees Mr. Olson looming over his father, or where he learned his father was seated afterwards. He sees Mr. Olson appear to step down, as if he's getting off his seat or somehow moving down. Mr. Olson walks down the aisle, and Matthew Reeves grabs Mr. Olson by the wrist, lays him down, and begins compression. That shows you what sort of family this is. That shows you what values Matthew Reeves was raised with. Now, there are several witnesses that were in the theater, several patrons. The problem with that is that what the police did is they, Corporal Gillard in particular, got about 20 of them together, put them in the left front area in front of the movie screen, gave them witness statement forms without giving them any instruction not to talk to anybody. We'll have witnesses that are saying that everybody was gossiping, everybody was talking about it. Matthew Reeves will tell the court that when he left the theater, after he went up and got his mother, after Mr. Olson was being attended to by a nurse, Matthew Reeves will tell you that as they were seated at some tables in the lobby where there were other patrons, again waiting to be interviewed, people were talking. People were saying, "This is over popcorn." And he took his mother into another room to get her away from the area. The point of that is there was a horrible contamination of the witnesses, and even though there were all these police officers, nobody tried to do anything to stop that. Nobody gave them any instruction not to speak to anyone. Now, there is a video in this case. And what's interesting about that is that night, Pasco County Sheriff's Office doesn't ask to see any kind of surveillance. It takes them 2 days to go back. In the meantime, Cop Theater had taken the hard drives out back to their headquarters. So we have Mr. Reeves arrested, and we have the Sheriff's Office not even trying to look at the video until 2 days later. And when they do, they send somebody not from cyber crimes, not from some kind of computer tech division. They send a guy who's pretty good with IT, Aaron Smith. The court's going to hear from some experts. There's going to be an expert in forensic radiology who's going to be able to explain the x-rays and MRI that were taken of Mr. Reeves to show the degeneration in his spine, the arthritis in his hands, the narrowing of his spine where the nerves pass through. So there's documented evidence that there is this degeneration happening with Mr. Reeves. Hear from an aging expert, Dr. Donna Cohen. She'll explain how the aging population perceives themselves. And once they perceive their own vulnerability because they realize as they're getting older, that they perceive danger in a certain way. So she's going to be able to talk to the court about the process of aging and how aging people perceive themselves and the world around them. There'll be a forensic video expert that will explain the process of downloading and why the images look the way they do, and talk to the court about different techniques in doing that. We'll hear from a use of force expert, Dr. Philip Hayden. We'll hear from a crime scene reconstruction expert as well, Michael Knox. So essentially, we have kind of a unique situation because Mr. Reeves is both an old person, he's also a retired law enforcement officer. That's important because of his training and his experience in knowing what is happening in front of him. In this case, when Chad Olson is looming over him, is coming over the seat, is acting irrationally, is acting menacingly, is acting angrily in a movie theater of all places, and coming towards him, Mr. Reeves knows what he has to do in that particular case. And he acted reasonably because of his background, because of his training, and because of his situation. So for those reasons, since we're looking at Mr. Reeves' perception, you need to learn about Mr. Reeves, and he did act reasonably because of all the things that I've outlined in the court order.
Thank you, Mr. Michaels. State?
On January 13th, 2014, it was a date day. It was a date day for Nicole and Chad Olson. They also have children. One small daughter is in daycare. And on that particular day, they took it upon themselves to take her to the daycare, drop her off, and then they went to the bar, had some quality time together as husband and wife, and they decided to go to the movies. It was one of the first times that they agreed on a particular movie. They both wanted to see Lone Survivor. And I believe what you'll hear from the testimony of the witnesses, that even though Ms. Olson doesn't know exactly when Mr. Reeves arrived in the theater and sat directly behind them, they were there first. They settled in, they were eating popcorn. At some point, Chad Olson left and got some Twizzlers and maybe another Coke. Chad Olson does have a cell phone. He had it in the theater. He had the cell phone on. Now, what is significant is the timing. Now, you will be able to see during the theater view exactly the lighting conditions in the theater. It'll be set up to house light. You're going to hear the term mid-1. That is the light setting so people can walk into the theater so that they don't fall down and trip over each other trying to get to their seat. It is not the very dark lighting that you would anticipate for the feature movie. So what happens during the time period when the trailers are on, and when we have the house level at a setting where people can see their movements and where they're going? People are talking. People are coming in and disturbing everyone while they're getting to their seats as the trailers are going on. Mr. Olson is, in fact, using his phone in some fashion. There won't be any testimony that he was talking on it. but the screen was illuminated. Now, at some point, Mr. Reeves does take a seat behind Nicole. Now, I believe what you're going to hear from the testimony is that Chad Olson was sitting in his seat and Nicole Olson was to his left. Now, the seats in the theater are just a little bit, not right behind each other, but a little bit off to the side for viewing purposes. But for the purposes of me explaining it to you, Mr. Reeves was seated behind Mrs. Olson, and Mrs. Reeves was behind Mr. Olson. At some point in time, while the trailers are playing, while people are still walking in, while people are still stepping over one another, getting to their seat, while other people are still talking among themselves, Mr. Olson has his phone out and he's doing whatever you'll hear in the testimony that he's doing. It is for some reason that Mr. Reeves takes an exception to the light of an iPhone being displayed while trailers are being played. And at this point that Mr. Reeves has a non-consensual contact with Mr. Olson. Not once, not twice, but more likely 3 times, but at least twice. And during that time period, he leans over significantly into Mr. Olson's face and asks him to turn off the phone. I'm not going to try to tell you what the witnesses are going to say about the demeanor, how it was said, or what words were said. You'll hear that during the testimony. But suffice it to say that Mr. Olson took exception to that non-consensual contact. He wanted Mr. Reeves to just leave him alone. Mr. Reeves then took it upon himself after the at least 2 contacts with Mr. Olson to then leave and go complain to the manager. What Mr. Michaels didn't tell you in his scenario is that when Mr. Reeves came back and walked behind Mr. Olson, he did not see the phone. Whatever was disturbing Mr. Reeves to the point that he felt that he had to have this non-consensual contact with Mr. Olson, not once, but not twice, whatever was going on that was so significant to Mr. Reeves that he felt that he had to get up out of his seat and miss the previews that the light in his eyes was disturbing so that he couldn't watch, he went and complained to the manager, and when he came back, that was over. The phone was out of the way. Mr. Reeves told that to law enforcement. As he's walking back, sitting down, I did not see the phone. Now, whether or not it was an apology or what statements were made, you'll hear from the witnesses how Mr. Reeves then rekindled that contact with Mr. Olson, knowing that Mr. Olson was taking exceptions to the non-consensual contact to start with. He rekindled it. Said, words to the fact, hey, I see you put your phone away. Whatever, you'll hear it from the witnesses. You're going to hear the witnesses through Nicole Olson and some of the other witnesses that observed certain snapshots in time. You're sitting in the movie theater and the witness will tell you, we were watching the previews. We could see what was going on between these 2 guys. Maybe we wanted to look, maybe we didn't, but every time they looked over, they saw a snapshot in time of what occurred. And each of the witnesses have various different snapshots that they saw. And it's for us to try to figure out, can we put that together for some type of meaningful event that took place so we can make a decision in this case. But the bottom line is that after that comment, you will see in the video Mr. Reeves leaning forward again. So this is the second time after he comes back from the manager that he makes the non-consensual contact with Mr. Olson after the event that he complained about was over. You'll be able to see through the video, and the video is also snippets of event. There's a motion sensor camera. There is some no recording, sometimes for a second, sometimes for 5 seconds. But you have to keep that in mind as you watch the video so you can discern and put proper meaning to the content of what you see the participants in the video doing. But it's at that point that, again, Mr. Reeves, the protagonist, the non-consensual contact with Mr. Olson, again makes contact, and Mr. Olson responds. Now, what you're going to see in the video is that there is a grabbing of the popcorn. There's a hand that comes in, comes back out, popcorn is tossed, the popcorn lands in the area of Mr. Reeves, and the hand comes back. And what you're going to see when you start sequencing the event is that as Mr. Olson brings his hand back from tossing the popcorn, that Mr. Reeves is in the process of drawing his pistol. It's at that point that after Mr. Olson is retreating from the immediate area of Mr. Reeves, he is no longer in his space. He's in his side of the aisle. Mr. Reeves is pulling his firearm from his pants pocket. He is leaning forward. He presses that firearm towards the area of Mr. Olson and shoots him right in the chest, in the area of the heart, just above the nipple line. The significance of that, Judge, is what you're going to hear from the witnesses, is that prior to the shot being fired, Mr. Reeves said, "Throw popcorn on me, will you?" Bang! When we talk about self-defense, when we talk about stand your ground, the court is well aware that what we're talking about is it reasonable. With a reasonable person, believed under the circumstances, knowing what Mr. Reeves knows, was it reasonable and necessary? Was it reasonably necessary to prevent immediate great bodily harm, death, or a forcible felony? If I could use the analogy of Goldilocks. Too hot, just right, too cold. When we talk about stand your ground, it has to be just right. It is to prevent. Once the popcorn is grabbed, once the popcorn is tossed, that is over. He can't prevent that by shooting Mr. Olson. As Mr. Olson is coming back in a submissive, non-aggressive stance, with his hand coming back towards him, it is Mr. Reeves who made a decision that was too late. By his own statement, he knew that the popcorn had hit him in the face. By his own statement, he says, "Throw popcorn in my face, will you?" His conduct is nothing but retaliation for the very embarrassing act of having popcorn from a former police officer who is used to having people do what he said. It's a sad situation. It's very sad. Was he scared? Yes. The court is well aware of being scared doesn't make it reasonable. You have to look at the timing of the threat. Was there anything for Mr. Reeves to prevent after the tossing of the popcorn? What was it that was taking place? It can't be an assumption, well, I got popcorn tossed on me, a bag, fluffy popcorn is now on my body. Then the next thing that has to occur is this guy's coming over the seat and he's going to pound the crap out of me. That's the assumption that can't be made. You have to look at exactly what the actions of Mr. Olson were. So when we look at this case, and when you hear the witnesses and the cross and the testimony that's going to be put on, I think you'll be able to see that first, there was no cell phone fraud. I think that's going to be clear once you hear all the testimony. It wasn't fraud. There is no injuries consistent with Mr. Olson's face. There's a small, possibly abrasion on his eyelid. underneath his license. There's nothing to indicate that a cell phone was thrown and hit him in the face. And through the other testimony and expert testimony, I think that'll be clear. What you have is the grabbing and tossing of popcorn and retaliation by Mr. Reeves of shooting of Mr. Olson. It's the retaliation. Applying the Goldilocks rule, he was too late. What he did was after everything occurred and there was nothing to prevent. And under that circumstance, Mr. Reeves is not entitled to immunity. Thank you.
Thank you, Mr. Murphy. Mr. Escobar?
Soon enough, Your Honor, tomorrow is my turn.
Mr. Michaels?
Call Jennifer Shaw.
Jennifer Shaw?
Do you swear from the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Go ahead, Mr. Michaels.
Please state your name.
Jennifer Shaw.
And is it Mrs. Shaw?
It is still Mrs. Shaw, but I am in the process of going through a divorce.
What is your maiden name, please?
Reeves,
And how are you related to Curtis Reeves?
he's my father.
And your mother's name?
Vivian Reeves,
How long have they been married?
this year in October it will have been 50 years.
And do you have any siblings?
I do, I have one brother, Matthew Reeves.
And how old is he?
He's 40.
What does he do for a living?
He is a police officer for the city of Tampa.
And what do you do for a living?
I am a branch manager for a bank here in Dade City.
And do you have any children?
I do, I have one daughter.
And how old is she?
Her name is Madison and she's 5.
And do you have any family in the area?
Yes, sir. We have pretty much all of my family on my mom's side and my dad's side live here, all of my immediate family. I have one uncle that lives in Oklahoma, but outside of that, everybody's in the Tampa, Orlando area.
And would you describe yourself as a close-knit family?
Very much so. We get together on all of the holidays and have barbecues and get the kids together to play and all of that.
And where do you live?
I live in Brooksville with my parents.
And how long have you lived with your parents?
I've lived with my parents since April of 2013.
And is that because of the divorce and that situation?
Yes, sir, it is.
And does your daughter live there as well?
Yes, sir. I have 50% custody with my daughter, and the other half of the time she's with her father. When she's with me, she does live there.
Now, where did your parents live prior to Brooksville?
They lived in Lutz,
For how long?
gosh, for as long as I can remember. The same house that I was born in. They moved to Brooksville in 2005. So, and I was born in 73. So for that period of time, I'm not sure how much prior to that they lived there.
And why did they move?
I think part of the reason
No,
was,
I'm going to object. Calls for speculation. May we approach, please, Judge?
Yeah.
is that correct?
Yes, sir.
Now, were you aware that what your father did for a living?
Yes, sir, I was.
Okay. That he was a police officer?
Yes.
Did you become aware that he also went to college while he was a police officer?
Yes, sir.
Tell me, then as a child, I guess you must have never seen him around the house. Is that true?
No, sir, not at all. I'm not sure. I mean, everything's so busy and rushed, it seems, today, and I don't know how he fit in all the time with the family that he did spend.
What sort of things would he do with you?
My brother played soccer, and my dad
I'm gonna have
coached
to
the
make
team.
402 objection.
Overruled for now.
I was in Girl Scouts, Matt was in Boy Scouts, I played piano. My dad was involved in all of those things, earning badges. Like, if you're familiar with the Girl Scout and the Boy Scout manuals, you can earn different badges by doing different things. And there were weekends where my dad would open the book and say, you know, let's do this one this weekend and that kind of thing. But I don't really remember, when I think back on my childhood, a time that he wasn't present.
Now, like all children, I would imagine you weren't a perfect child.
No, sir.
So did there come a time when you were ever disciplined
Yes, sir, I was.
by your father?
I'm going to
Yes.
object 402 relevant.
Sustained. Let's move on.
Judge, if I may, again, this is an issue regarding the prosecutor has made an argument, frankly, during opening statements that Mr. Reeves acted out of anger, and Mr. Reeves acted in a way, in a revengeful way, because he didn't like popcorn thrown in his face. I think his character is relevant throughout the years of painting a picture that that's not the kind of man he was, that he was a kind man. Even in punishment, he didn't react out of anger. That's what I'm trying to get out of this witness.
Right. I agree. I'll allow that.
My only objection would be is the timing. I mean, we don't even know, this could be 30 years ago. So my objection is 402, and without the timing, we have a 403 argument. People change.
I'll allow it to that extent, but let's, again, stay focused.
Okay, what kind of age were you at when we're talking about spankings?
I would say 14 and younger.
Did your father ever spank you while angry?
Not that I can remember. I mean, I made him angry plenty of times, but usually the kind of the protocol that Matt and I would remember is being sent to our room to think about what we've done, and then he would come in to talk to us about it, and there was a discussion that took place, and then he decided whether or not you were getting spanked, or if you were going to be on restriction, or both, but I was never slapped or spanked or hit out of anger right at the moment.
Now, as a child, I remember learning how to cuss driving around with my mother, frankly. You had occasion to drive around in a car with your father when you were younger?
Absolutely.
Did you ever see him exhibit any kind of road rage of any sort?
No.
Yeah, no, object, 402, Singleton at the bench.
Not as a child or as an adult.
Excuse me.
I'm sorry, Your Honor?
How about a time frame?
Okay. Tell me whether you remember any specific incident, an accident or something, your father's reaction.
Yes, sir. I do remember, and it's been, it might have been like 13 or 14. We were rear-ended in North Carolina camping.
Excuse me, Judge, I'm going to object. If we're talking about character accidents, character evidence cannot be proved by specific acts. It has to be with the reputation of the community. So I object to the form of the question and the admission of specific acts as it deals with character pursuant to the evidence code.
Response?
Again, Judge, it's a similar argument. The allegation here is that Mr. Reeves acted in a certain way because he didn't get his way. And certainly the prosecutor has made it an issue now here at the trial. And so I think it's fair to flesh out what his character was throughout the years to determine whether or not his actions were reasonable. the prosecutor may not have a problem with this perception. I don't know, we'll get to that, but if we're talking about what Mr. Reeves' reaction was, then certainly it's relevant because it goes to what his character was, and it goes to what his background is.
Response.
Judge, he indicated exactly what I objected to. He wants to go through specific incidences over time, saying at this time, this did not occur. That's not the way you prove character by reputation within the community. And as the court's well aware, in the immunity hearing, the rules of evidence apply, strictly apply. I object to specific incidences in order to prove character that would then to argue that the character on 1/13/2014 is consistent with specific incidences, and that is not acceptable under the rules.
All right, for purposes of this hearing, I'm gonna be I'm gonna allow a little more than I might, or I'm not gonna be quite as strict as I would if we were having a jury over there. Obviously, I'm the trier of fact. The rules of evidence apply. I'm going to allow some of this testimony for the big picture of Mr. Reeves, who he is. As far as character evidence, Mr. Martin is correct that this isn't, it's not really appropriate to show his character. Clearly, there is the insinuation and argument or statement by the prosecutor that this was done out of anger and resentment at having someone tell him, not respond in the way that Mr. Reeves indicated. That was in the opening statement, no doubt. Is this proper testimony for character? Unless you're going to have, a 10 or more witnesses as to that, I'm going to have to agree with Mr. Martin. But this sort of evidence, in my humble belief, is similar to hearing testimony about someone wearing a seatbelt. They always wore a seatbelt, always wore a seatbelt. Did they wear a seatbelt on the night in question? We don't know. So I'm going to utilize it for that purpose. It certainly will help me get an understanding of Mr. Reeves' background and who he is, which is what the defense is hoping to do. So for all of those reasons, I'm going to allow this line of questioning. Again, though, let's not go too far with it.
Did you ever see your father react angrily as a result of an auto accident?
No, sir.
And do you have any specific examples?
Just the one that I started talking about where we were rear-ended in North Carolina and it bent a rack that my father had on the back of his car. He got out of the vehicle, resolved it amicably, told the guy, don't worry about it. He would bend the rack back and fix it, and it was over with.
Now, the man you married was a police officer, correct?
Yes, sir.
Do you remember going to your father and telling him about the divorce?
Yes, sir, I do.
Tell me about that. How did your father react?
Your Honor, I could object 402.
Overall,
How did your father react? Did he try to get involved and tell you what to do? What was his reaction?
No, sir. My father was very angry because my husband had been unfaithful. But
Your Honor,
he
again,
didn't.
we have not only a 402 argument, but now even a 403 argument. Even though you're the trier of fact, this is a type of testimony that's totally inappropriate.
response.
Judge, I'll ask a different question.
Thank you.
Did your father try to take charge of the situation?
No, sir, he did not. He just offered support and let me know that he was there and asked if I wanted him to come over.
So he didn't tell you what to do?
No, sir.
You didn't confront your soon-to-be ex-husband?
No, sir.
Growing up, do you remember your father being into fitness at all?
Yes, sir.
Tell us about that and give me a time period of when you remember.
Growing up, Dad had to maintain being physically fit for the police department. He also was commander of the SWAT team, and he had to maintain a high level of fitness for that. For a number of years, I remember as a teenager, he would run at night. He would go out running, and I don't ever remember him being heavily involved in a gym or a gym membership or anything like that, but just really staying active at home and the running piece.
And at some point, did he stop running?
He did stop running.
And around what time period are we speaking of?
I'm not certain of the time period. I'm going to guess it's somewhere right around 14, 15. He had a problem with his sciatic nerve that
Your
bothered
Honor,
him
I'm going
greatly.
to object. It calls for speculation and lay opinion as far as the medical condition.
Sustained.
Okay, let me ask you, did you observe your father having difficulty running?
On several occasions, I couldn't keep up, but I tried to run with him.
Okay, but at some point, did he have difficulty in running?
Yes, sir, he did.
Okay, and you observed that, correct?
On several occasions. I didn't run with him all the time, but I have observed that.
And at some point, did he stop running?
Yes, sir.
And do you know how old he was?
I'm not certain.
Do you know how old you were?
I might have been around 14 or 15.
Was he still at the police department when
Yes.
he stopped running?
Yes, sir.
And do you know if he stopped running because he got lazy?
No, sir.
Your Honor, again, it calls for speculation.
No overrule. Tell what she observed.
Did he take up another form of fitness?
Yes, sir. He took up riding a road bike or bicycling.
Okay. And again, to maintain cardiovascular fitness?
Yes,
Your
sir.
Honor, I'm going to object. Leading and it calls for speculation.
Sustained.
Now, let's talk a little bit about your mother, okay? How old is your mother?
My mom is 70.
And do you know if she was being treated at a hospital of any sort?
Your Honor, I'm going to object to this line of questioning as being not relevant for 402 based on the discussions that have been.
Judge, it's relevant because we have an elderly woman who also is declining in health in the movie theater. Certainly, Mr. Reeves is justified if he's acting to thwart an attack or thwart any imminent threat of attack to himself or to his wife. So I think it's important that we hear this testimony so that we can understand Mr. Reeves' state of mind and his perception with the big picture that he is sitting next to his wife and she is also in declining health and getting older.
Then Mrs. Reeves can take the stand and testify when, where, and why she was in the hospital and where she was sitting. But for Ms. Shaw to come up here and be a conduit for Ms. Reeves is inappropriate.
To the extent that she has personal knowledge, and that alone, I'll overrule.
We'd ask for a date.
And times.
Do you know any specific dates
No, sir.
or time periods?
Well, I know that she had a knee replacement in the last couple of years. She's also,
Your Honor, it's not a response to the question. The question was, do you know any of the dates when she was in the hospital? And now the responses are hearsay and calls for a medical, not testimony, but the only way she would know that if Mrs. Reeves told her, therefore it's hearsay.
She's her daughter. To the extent that she knows, I don't need medical details, just a basic recitation of time period and procedure.
Okay. So about 2 years ago, do you agree or disagree with me that about 2 years ago, your mother received some sort of treatment?
yes, she had a knee replacement.
Okay. So she had some sort of surgery, that
Yes.
fair to say? And do you agree or disagree with me that your mother has also been visiting Moffitt Cancer Center?
Yes, sir.
And is that for a period of years now?
Yes, sir. It's been over a period of years.
Now, are you aware whether or not your mother and father exercise together?
They do on occasion. Yes, they do.
And what sort of exercise?
Sometimes they will, well, prior to, what time frame are we talking?
Prior to 2013?
Okay, yes, sir. They would walk together in the neighborhood. At that point in time, I guess my mom's doctors at Moffitt had told her there was a possibility she might have to have surgery and that she needed to get in shape so that her
Again,
recovery.
we're talking about, I object. First, it's hearsay, what her mother told her, and the question was walking, so it's non-responsive also.
Sustained, let's get back to.
Thank you, Judge. In between 2013 and 2014, did your mother and father exercise together?
Yes, sir.
And what sort of physical activities did your father do between 2013 and 2014 that you're aware of?
Together?
Just your father?
Oh, just my father. He walked with my mother. He also rode his bike. And then he did calisthenics, just kind of stretching exercises.
And what sort of bike did he ride? Was it a road bike or a mountain bike?
No, typically, well, he has both bikes. If he rode with my mother, he would typically ride a mountain bike. And then if he rode with friends or by himself for exercise, more so for exercise, he would ride a road bike.
Okay. And let's talk about your daughter. Her name is Madison.
Yes, sir.
And how old is she?
She's 5.
When she was born, that means was your father already retired at that point?
Yes, sir, he was.
And tell me whether or not your parents helped you to care for the newborn.
Yes, sir. I stayed home with her for 3 months, and then they kept her for 6 months before she went into daycare.
Are you aware of any plans your father had for retirement before Madison came?
Yes, sir.
Your Honor, again, I would object. We're far afield based on my objection at the bench for 402.
Response?
Judge, we're getting background on Mr. Reeves. We're trying to paint the big picture here. We're going to get to the police certifications. We're going to get to all that, but that's not the only person he is in that theater. He's both sides of that. I think we can expect that the prosecutor's going to argue something to the effect of, well, he's a retired police officer who didn't get his way, and therefore he's being authoritative, and that's what this is all about. And so I think that it's important to hear that in retirement, that's not what Mr. Reeves is about. In retirement, he's a family man. In retirement, he's a grandfather. In retirement, he's not a police officer 24 hours a day.
Again, Mr. Michaels has identified specific acts of conduct that they want to be able to argue that he acted in conformity therewith on January 13, 2014. The court's well aware of specific acts of conduct and regarding character to determine how a person acted on a particular time is not admissible. It's character by reputation within the community. That's how we prove character, not by specific actions.
Response to that?
Judge, I'm going to connect it up to his disabilities and actually interacting with the child. And so this is just kind of laying the foundation to get to that point.
We're laying a pretty big foundation. Let's narrow it down a little bit, but I'll overrule.
Okay. So are you aware of whether or not your father changed his retirement plans in order to stay home with the child, with your little girl?
Changes his plans in retirement, not to retire. He had already retired, but yes, he did. Him and my mom decided not to travel and to stay home and watch Madison.
Okay. And did they help you take care of Madison
They did.
For how long?
It was about 6 months.
And whose idea was it to do that? Was that your idea?
No, sir, I hadn't even discussed it with my parents because I knew their travel plans. And I knew having a child was my responsibility and my husband's responsibility. So no, I never asked them to watch her. It's something that they came to me and said, we feel like this is important for family and we'd like to do that.
Now, when Madison was a toddler, did your father play with Madison? Did you observe that at all?
Yes, sir, I did.
What sort of things would he do with her?
He would do all kinds of things with her. There were limitations as far as him crawling around on the floor and the things that she wanted him to do. But he played with her all the time as far as reading her books and playing games with her and singing songs.
Now, when she was a baby, when she was a toddler, did your father pick her up?
I have seen him pick her up, yes, sir.
And is he still able to do that?
No, sir, not really. I don't think I've seen that in the last couple of years.
And do you remember an occasion where your father was trying to play with Madison on the floor and couldn't get up?
Yes, sir.
Your Honor, again, I'm going to object to the leading nature of the question at this time.
Judge, number one, it wasn't leading. I asked her if she remembers. I didn't say, you remember, don't you? That's leading. If I give the witness a choice to answer the question yes or no, that's not leading. Number one. Number two, if we're going to talk about the degenerative process here, certainly Ms. Shaw's observations of her father's limitations and his diminishing capacity are relevant in this case.
Follow the rule.
Judge, it's only relevant if we have a date. Every question needs to have a date frame, otherwise we're just throwing it out there and we can't make it relevant without a date.
Time frame.
Okay. How old is Madison now?
She's 5.
Okay, so that means she's been here on this earth 5 years. So it was sometime between the time she was born and now, right? When your father couldn't get up?
Yes, sir.
Okay. Do you know more specifically, was she 2 years old, 3 years old, 4 years old? How old was she?
I've seen it on more than one occasion that's occurred. It's rare that he gets down on the floor with her, but when he has, he doesn't get up very easily, and it takes a little while and a little help.
Okay. And does he ever try now to get on the floor, or that's over with?
No, sir, I think that's over with.
Now, when you were growing up, what were the sort of things your father did with his hands? What sort of hobbies? What did he like to do?
He did woodworking. He did leather work. I can't remember what he couldn't do. He can kind of do a little bit of everything. So.
Does he still do woodworking?
He has tinkered with it, being confined to the house. I think one of his friends got him into making some toys for churches around the area, and brought him the wood and the patterns and the materials he needed to make those toys. So Dad's been making toys for those kids.
Okay. Does he work at it like he used to do for hours at a time? Or
No, sir, not at all. And I believe I heard him say at one point in time he even
Your Honor,
simplified a
I'm
couple of the
objecting.
patterns.
Here's-
I'll move on, Judge.
Thank you.
Now, as a child, would your father kind of take you out and do things in the great outdoors?
Yes, sir. We spent most of our time outside as kids, riding bicycles, hiking in the woods, camping, fishing, canoeing.
Okay, and kayaking?
Yes, sir.
And have you kayaked recently with your father?
The last time we went kayaking was actually in April of 2013.
Okay. And at that point, did he have any difficulties with any of the equipment associated with kayaking?
Yes, sir. The paddles were 2-part paddles that you put together and have to pull apart, and he wasn't able to pull them apart.
But in that instance, and is it true that the paddles were pretty stuck and you had to help him pull it apart?
Yes, sir.
Have you ever seen before that on occasion where he couldn't pull them apart and they weren't that difficult to get apart?
Not that I've witnessed.
Your father got a motorcycle after retirement. Is that true?
Yes, he did.
Okay. You didn't have any problem riding it, did he, or did he not?
The riding it part, I don't think is the hard part. I think the getting on and off and getting started and stopping and that kind of thing. From my
Again,
perspective.
I'm going to check. She kept saying, I think this is a problem, I think this is a problem. And when he retired from Tampa Police Department, he retired from Busch Gardens. Again, we don't have time frames.
Let's get specific timeframes, and if she doesn't have personal knowledge, then I'm not gonna know.
Have you had occasion with your husband to be on a motorcycle?
That is correct.
Have you had occasion with your husband to be on a motorcycle and have your father and your mother also on a motorcycle at the same time?
Yes, sir.
On their own motorcycle?
Yes, sir.
Now, what time period are we talking about? You obviously were with your husband then.
Sure. It would have been prior to the birth of my daughter. So it would have been the several years prior to February 2nd of 2012.
Okay. And you observed your father getting on and off of the motorcycle, correct?
Yes, sir.
And was it a smooth transition? Was he just able to swing his leg over and get on the thing or not?
No, sir.
Describe what you observed.
As a child, kind of watching that and watching my mother get on and off the back, it's a little scary. But occasionally he would have to kind of tell her to stop, wait a minute, let me hold the bike up, that kind of thing, to try to get them both on and get them going. So no, it wasn't a swing your leg over and get on.
Now, are you aware of whether your father had a fall in December of 2014 in the house?
I can't remember the exact month, but yes, sir, I'm aware of when he fell.
And
Your Honor, I'm going to object to this testimony. It occurred after the incident of January 13, 2014. What occurred and what injuries occurred afterwards is not relevant to this particular case. If they can try to tie it up with Dr. Foley, then we'll see if they can do it. But right now, I'm suggesting in court that there is no relevancy because it's after the incident. Therefore, it would not be part of the knowledge that Mr. Reeves knew at the time of January 13, 2014.
but it would be evidence, Judge, of the continuing aging process. It would be evidence that part of the degenerative changes Mr. Reeves was suffering from is lack of bone density. Mr. Foley will indeed be able to testify as to that's what happens. We're going to be able to look at the x-rays. The court's going to see that he has an artificial hip in the x-rays, and Dr. Foley is going to be able to say that old people's bones get brittle, therefore when they fall, they can't take it like when they're young, and therefore Mr. Reeves had this degenerative condition. Dr. Cohen's going to further be able to tie it up by saying that's what happens with old people. That's how they know they're vulnerable. Here's further proof that this is a vulnerable old man. So I believe that it is relevant in this case, even though it happened post January of 2014.
Any further response?
Very well, briefly, Judge, the relevancy, as the court's well aware, is the knowledge of the defendant on January 13, 2014, at the time of the shooting. He had none of that knowledge. It cannot be considered as being one of the factors. Whatever happens before that, I believe is probably fair game, but not afterwards.
May I respond as well?
One at a time.
Didn't we have a moment
You
then?
may.
Maybe Mr. Escobar put a little more articulate than I did, articulately. essentially this is relevant because it goes to show the difference between an old person and a young person. In this particular instance, Mr. Reeves on the back porch, playing with his granddaughter, walking there, falls, breaks a hip, needs a hip replacement. And that doesn't happen to a 43-year-old. And so it's relevant to show the aging process, to show his vulnerability, to show that he had recognition of his vulnerability.
How can anything really that happened afterwards be considered relevant to his state of mind and feelings at the time?
Because his feelings at the time were that, hey, I'm an old man. I can't take a punch from somebody. I can't, because if I do, I could sustain great bodily harm. If I do take a punch from somebody, I could die or be killed. And so this is further evidence that that was true. Not only is it a perception, but it was true because his bones are deteriorating.
All right. They're just, I can't allow stuff after the event. It just doesn't jive. And I don't really need corroboration from a witness to say that this happened afterwards, to know that every day that goes by, we all age, so I get it. I don't need to hear about stuff that happened afterwards just to corroborate that. And I'm not seeing any other purpose for it, and it simply can't have any relevance to his state of mind at the time of the incident, so I'm going to sustain.
Now, growing up, your father was a police officer. Did he treat you at home like a police officer treats a suspect?
No, sir.
Your Honor, I'm going to object to that. How would she know how he treats someone on the street?
I'm going to sustain. I mean, rephrase.
Okay. Growing up, was your father a bossy, authoritative person?
No, sir.
Do you agree or disagree that your personality is similar to your father's?
Yes, sir.
And what do you mean by that?
Just my brother's more similar to my mom. I'm more similar to my dad in that my dad and I are pretty direct people. When we have something to say, we say it. We can be kind of stubborn at times, and
Do you agree or disagree that your father made all of those things, but he's not an aggressive person?
that is the truth.
Now, you know your father was in a position of authority all those years in the 10th Police Department, do you not?
Yes, sir.
Now, tell me why you think your father was in a position of authority.
My father was in a position of authority based on his leadership skills.
Your Honor, I object to that. That calls for speculation. As opposed to, she said, I saw his captain's badge. He's a captain. Well, he's a supervisor, but not what, character-wise, why he was in a position of authority.
Response?
Judge, one of the issues here is that he's a captain, has a captain's badge. And so the state has essentially made this an issue here as to whether or not Mr. Reeves acted in a way that shows he was a frustrated police officer, a captain who always got his way, that sort of thing. This testimony is to demonstrate that that wasn't who Mr. Reeves was. That again, we have to look at kind of the dichotomy. There's the job that he did, and there was Mr. Reeves as a person, both before he retired and after he retired. So I think it's important that Ms. Shaw be able to testify concerning his leadership ability, as opposed to, he was in a position of authority because he was an authoritative kind of a guy.
Any further response?
Quickly, there's no way that she'll know how the deciding individuals at the Tampa Police Department made a determination to promote Mr. Reeves from one position to another. That criteria is unique to the police department itself, and there is absolutely no way that Ms. Shaw could have even an inkling of an idea of that process and what they would go through in order to make those promotions and place him in a leadership position.
And Judge, that may very well be true. She's not part of the police department, but certainly as his daughter, she saw him in church, leading the congregation. She saw him in the Boy Scouts, being a leader in the Boy Scouts. She saw him in the Girl Scouts, being a leader in the Girl Scouts. She saw him as a coach during Little League Soccer. So she's seen him in leadership positions, and it's not a stretch for her to say, my father was in a position of authority. I know because I see what a fabulous leader he was.
Again, we're back to specific instances of contact to confirm that someone acted in conformity therewith on a particular date. I apologize for keep standing up and doing the objection, but it's over and over and over again.
All right. Mr. Michaels, clearly we're getting into exactly what Mr. Markin has objected to. Mr. Reeves' character is not an essential element of this crime alleged. So the rules are kind of clear that in specific instances of acting in conformity to a certain character is not admissible. So we're going to have to really limit where you're going with this witness. And unfortunately, we've spent more time talking about her testimony than we've actually heard. But Mr. Martin's correct. Let's tailor this down to what might be admissible evidence and move on.
And so just so I understand the court, then the state can't argue later that Mr. Reeves acted in conformity with some kind of authoritative personality he had as a police captain. Is that what I understand?
That sort of, this sort of testimony might be brought out if the door is open through cross, but not to just be offered as circumstantial evidence that he acted in conformity with some character. So, to answer that in a nutshell, he may open that door. I wouldn't, from what I've heard already, that may very well be a possibility. And at that point, of course, there's the opportunity for rebuttal or further cross, depending on who the witness is.
And one moment, Judge.
You may.
describe for the court specific instances of observations you made regarding your father's deterioration or limited physical capacity.
I'm just asking for a time frame, Judge, again. Just, I assume we're talking about prior to January 13, 2014. So when prior to that would be helpful.
Judge, I asked for specific instances, so I don't know. I'll wait to see what she says.
We'll see what she says.
Will you repeat the question for me, please?
Specific instances of observations you made regarding your father's diminishing capacities.
Sure. I've watched both of my parents over the years deteriorate basically in age as part of the aging process. It's not that I put a time frame around any of that and can tell you that on this day, this is what I observed. But what I have observed is that my parents had trouble functioning on everyday normal activities that you and I take for granted. But I can't put a time frame and say that on this date he couldn't tie a shoe, and I've seen that. And I can say a time frame on this day his fingers locked up and he couldn't hold a cereal spoon, but I've witnessed that. But I can't tell you the dates that occurred. I can't tell you the date where he tried to pick up Madison and had to put her back down because he couldn't stand up or hold her. I don't know those dates, but those are things that I've witnessed and that I see on a daily basis. You know, I've witnessed my daughter imitating his hands locking up and saying, "Oh, look, Grandpa, my fingers won't move." I've seen her use examples of when she doesn't want to do something. I think my hip is hurting, or things like that. Those are things that a child notices. So yeah, I've seen all of it. I've seen the deterioration. I've seen them not be able to do what they thought they could do. I've seen my dad push his limits to try to stay healthy and thinking that he's doing his body good after all the damage he's put it through, whether it be with police department training or SWAT team training. He was determined to slow down that aging process by staying physically fit.
But now we're getting into speculation about what may or may not have occurred at the police department, what he felt that he needed to do. The question was specific. What are the observations? And I let it go to an extent, but now she's just speculating about what Mr. Reeves is thinking about over the years, so I object.
Sustain. Let's move on.
You shoot sporting clays?
Yes, sir, I do.
And how were you introduced to that?
Through my father and my ex-husband.
And what is that exactly?
It's where there's clay pigeons that are around a machine or a trap throws the pigeons into the air and you fire and shoot them with a gun.
And what sort of shotgun did you use?
When I was married, I used my husband's gun, which I believe was a 12-gauge Browning. And then I've been using the gun my father gave me, which is a 12-gauge Benelli Super Sport.
And is that a gun that your father also used when he would shoot clays?
Yes, sir, it is.
And tell me about that gun. Is there a lot of recoil? Does it hurt to use it?
No, sir, not at all. I think one of the reasons my father bought it is because there isn't.
Your Honor, again, I object. Speculation, and if she knows, if he said, it's hearsay.
Was your father able to shoot with that gun?
Yes, sir, he was.
And did you observe him shooting with the gun?
I did.
And was he able to shoot with that gun, or was he able to shoot with other guns before that?
I'm sure he did, yes.
And when did he get that Benelli Super Sport?
I'm not sure when he acquired it.
Okay, was it sometime after you retired?
I believe so, yes, sir.
Was it sometime after you noticed the kind of changes in his ability to do the things that he could do before?
I'm not certain on that.
In other words, was it around the time he couldn't pick up your daughter and those sort of things?
I'm not sure if he bought it before or after that. I know that I don't think it's a very old gun.
Okay. And is the gun light, is that fair to say?
Very light.
So you didn't have any problem shooting it?
No, sir, not at all.
In fact, your mother could shoot it as well, is that true?
Yes, sir.
Can I have a moment, Judge?
You may.
Now, before you were interrupted by the prosecutor, I know you were talking about the changes you saw in both of your parents. Do you remember that?
Yes, sir.
Did that happen before January of 2014?
Yes, sir.
I don't know if it was. Thank you.
Well,
Thank you. Good morning. We'll start backwards a little bit, so it's just a little bit fresher in mind. Let's talk about the sporting clays, all right?
Okay.
Is that the Tampa Bay Sporting Club here
Yes,
in
sir.
Pasco?
Tampa Bay Sporting Place, yes.
Yeah. Okay. How many times have you been there? And I'm going to keep my questions to prior to January 13th, 2014. How many times were you there with your dad in 2013?
Maybe half a dozen.
Okay. You familiar with the course?
Yes, sir.
There's 2, 3 courses there?
3 courses.
And have you fired on all 3 courses?
I have.
I'll call it a path or a road, but it's a road kind of narrow, maybe for an ATV or a truck just to get by, but most people walk it, golf course.
Yes, sir.
All right. Made of dirt.
Yes, sir.
While there is some slight elevation, it's relatively level.
Yes, sir.
All right. When it rains or whatever, you can see for a while small indentations, potholes, maybe some gravel from the water, but pretty much it's just level, flat with a gravel dirt road, right?
It's not gravel, it's just dirt.
Just dirt.
Yes.
Okay. Hard packed dirt, soft dirt.
There's areas of soft dirt, but mostly hard packed.
All right. Now, when you and Mr. Reeves go to that particular club, he normally walks.
Yes, sir.
And in 2013, he would walk those 6 times, right?
How many times? Oh,
Yeah.
throughout the year, yes.
Yeah. All right. He did not use a walker.
No,
He did not use a cane.
no,
He carried his own shotgun.
correct.
He carried his own shivs.
Yes,
All right. He didn't ask for any assistance to walk down that dirt road from station to station, did he?
correct.
All right. Now, did you shoot the 50-round course or the 100-round course?
Well, the courses are, you can shoot whatever you want on the course. We never use scorecards or kept score or anything like that. We typically shot 50 rounds.
All right. And there's 14 stations,
It depends. They've switched the courses up over the years. They change everything around.
so anywhere from 10 to 15 stations.
Sometimes less than that, depending on what course you were on.
But you would still shoot 50 rounds.
Yes, sir.
And at each particular stage, you would place that shotgun on your shoulder and shoot 2 flights, 2 birds, whatever you want to call it.
4 or 6 or whatever we decided at that station.
That is true. The shotgun and the rules are it holds 2 shotgun shells at a time. That's all you can load, correct?
The Benelli, yes.
Okay. Well, yours too.
Yes,
That's
sir.
the rules.
Correct.
Right? All right. So 2 birds will only come out at the time. If you want to shoot 4 while you're still at the station, then you're going to have to reload.
Correct.
All right. Now, in this particular case, you're talking about the Benelli Super Force, right?
Yes, sir.
All right. And were you shooting 2 3/4 shells or 3-inch shells?
I'm not sure.
Okay. Were you
Depending on
shooting
what was on sale.
whatever was on sale? All right. Fair enough. Were you shooting target loads?
I'm not sure what that is.
All right. Are you aware of the rules at the range that you're only supposed to use 7 shots?
Yes, sir.
Okay. So that's what you were shooting?
Yes, sir.
All right. Now, your particular shotgun, is it an automatic, semi-automatic shotgun, or is it a double barrel where you can actually open it up and break it? You know what I'm talking about?
Semi-automatic.
Semi-automatic. And you, in fact, inserted the shells into the loading port of your shotgun, right?
Correct.
And when you loaded your shells into the loading port of that shotgun, the loading port of the shotgun is underneath the shotgun right in front of the trigger guard, is it not?
Correct.
All right. And did you have the shotgun shells in your pocket or in a bag, in a box?
Usually on a pouch or in my pocket.
All right. And would you take it out one at a time?
Yes, sir, usually.
And what was your technique in loading the shotgun shell into the loading port? Did you push it in with your thumb? Did you push it in with your finger? Or what did you do?
I believe I use my thumb.
Okay. Now, in the tube that's underneath the barrel, where the magazine tube for the shotgun shells, there's a spring, correct?
I'm not sure about that.
When you place your shotgun shell into the loading port, you had to use force with your thumb to push it in into the loading port, did you not?
Yes, sir.
It just didn't fall in.
Correct.
Okay. And then when you took your second shell, you also then used your thumb and placed your thumb on the back of the shell and pushed it into that loading port, did you not?
Correct.
And the second one was just a little bit harder than the first one because the spring had been compressed, right?
Once you load the first one, you push a button and I don't recall it being any more or less difficult.
Okay, right. There's a button called a bolt release, and the bolt goes for placing the shotgun shell into the battery, correct?
I don't know the terminology, but
But you have to put 2 shells in, right?
correct.
And you did that.
Yes.
All right. Now, after you did that, and you placed your shotgun onto your shoulder, did you not?
Yes, sir.
All right. You put your cheek on the buttstock of the shotgun.
Yes, sir.
All right. And when the birds fly in front of the station, you actually have to hold that shotgun in your hand and wait for the bird, and then you swing the shotgun as the bird flies, correct?
Correct.
All right. If you don't swing the shotgun, what happens? You shoot behind the bird, right?
Or you just clean this.
You miss.
Over, under, behind, in front of.
Right. So the whole purpose when we're shooting sporting clay is to keep that shotgun moving while it's held up in the air. As the bird flies, we're constantly moving, and we pull the trigger as the gun is moving. Theoretically, the shot will fly in front of the bird, and you hit your target, right?
Correct.
All those are body movements that have to take place in order to participate in that sport.
Correct.
The stages that you went to at the Tampa Bay Sporting Clay, some of them have stairs that you actually have to walk up into the stage area, correct?
Correct.
All right. And you made it up those stairs.
Yes, sir.
All right. Now, not all of them have stairs, right?
No, sir.
But some of them do.
Yes.
All right. Now, when you were there with your father, he also had a semi-automatic shotgun, right?
He was shooting that same gun.
The vanilla.
Correct.
All right. Now, he loaded it the same way. He took one shell out, used his thumb, and placed that shell into the loading port of the shotgun.
I know he loaded the gun. I do not know his technique.
He had to use his fingers, right?
Yes.
A little bit tongue-in-cheek. That's the only way you can do it. You can't use your toes or your elbows, right? You have to use your fingers to get the shell into the loading port.
Correct.
Okay. So whatever technique he used his fingers, his wrist, his arm, in order to take the shell out and load that shotgun shell into the loading port of the shotgun.
Correct.
And he had to do that twice. And just like, is that correct?
Yes.
And just like you, he then had to place the butt of that shotgun onto his shoulder, right?
Yes.
All right. He's right-handed?
He's left-handed, but he does things with both hands.
Is he right-hand dominant when he shoots a gun, or
I have no idea.
does he place the shotgun on his right shoulder or his left shoulder?
I don't know.
He places it on one of them, though, doesn't he?
Yes, he does.
All right, fair enough. His technique has to be the same as yours. If you're going to be successful in shooting that bird out of the air, you have to hold that shotgun up for the amount of time it takes for the bird to fly. You twist your body, the shotgun in front of the shell of the bird, and you fire the shotgun while you're moving, correct?
Sure. And the amount of time you refer to is seconds.
Sure, sure. 2 seconds, 3 seconds, maybe 5 seconds.
It depends on the stand.
Right. So as you're going, and you have a little button there, right? And you ask the person, are you ready? Right? And you have to hit the button in order to make the bird fly.
Correct.
And while you're standing there waiting for the bird to fly, you're standing there with the shotgun up, ready to go.
Not necessarily.
Okay? What was his technique? There are two techniques, and you're correct.
Sure. I don't know.
Now, Mr. Reeves also walked up the stairs to the stations just like you did.
Correct.
Okay. While carrying his shotgun.
Yes, sir.
All right. With his ammo. Right?
Yes, sir.
All right. Again, he didn't ask for an elevator. A little facetious, I know. But he walked up the stairs with no problems, right?
Well, I mean, I don't know if he used the handrail or not. I didn't pay attention.
Sure. Mr. Reeves then would walk from station to station along that dirt road, right?
Correct.
Now, depending on the number of the stages and how many birds you shoot, what does it take, an hour and a half, maybe 2 hours to go through a particular stage?
I'm not really sure. Maybe an hour, a little over.
Right. And during that time, Mr. Reeves would be standing the whole time?
Yes, sir.
He'd be holding his shotgun the whole time?
No, sir.
All right. There is a station by the stages where you can actually take the shotgun and put it on a rest while another person shoots, right?
Correct.
All right. And then after you're done with that stage, you will pick up that shotgun and then you will safely carry it to the next stage.
Yes, sir.
Okay. And he carried his own shotgun.
Yes, sir.
Okay. Now, because the shotgun did not break, it was a semi-automatic, do you know if he carried it straight up, holding it with his hands? Did he put it on his shoulder and carry it? Do you know how he did it?
I don't know.
Okay. But he was responsible for getting his gun from place to place.
Correct.
Okay, we're going to move on, all right?
Okay.
All right. You talked about Mr. Reeves saying, quote, fingers locking up. You're talking about both hands?
Yes, sir.
All right. And you're talking about the index finger,
I think there's been several where it's been more than one finger.
including the index.
I'm not sure which ones.
Okay. And you say when that happens, that he can't hold a cereal spoon, right?
I've seen that happen.
Okay, all
I'm not
right.
saying that happens every time.
All right, and it goes away.
Eventually, yes, sir.
All right. You talked about, on direct, about you've never been with your father when he's been, or exhibited conduct that Mr. Michaels described as road rage. Remember, were you ever in the car where you got angry? Okay. You don't ride around in the car every day with your father, do you?
Not every day, no, sir.
All right. In fact, I think it would be best to describe that the great majority of the time you are not in the car when your father's driving. He's off doing his thing and you're off doing your thing.
What time frame are we talking about?
Talking about, let's just take it 2013.
No, sir. We went to family dinner and that kind of thing, but for the most part, correct.
Yeah, for the most part, the great majority of the time, you're not with Mr. Reeves when he's in the car.
Not in the car, no, sir.
All right. So when you indicated that you'd never seen that, that was based on your very limited experience of being with Mr. Reeves.
No, sir. That was based on a lifetime of being his daughter.
All right. Let's talk about the lifetime. Same question to you. Would you not agree that even though you grew up and you're his daughter, you were not in the car every time Mr. Reeves was driving on the street?
Correct.
You indicated that, and I believe the time frame was prior to January 2013, 2014, that Mr. Reeves had trouble picking up your daughter,
Yes, sir.
picking her up from the floor.
Correct.
All right. And with this, and I'm using the movement, and I'll try to describe it for the record, where my hands are down by the pockets of my pants, and I'm simply taking my shoulders and keeping my elbows locked like you would pick up a child underneath the armpits. Is that the motion we're talking about?
I wouldn't keep my arms locked to pick up my child, but
Okay, so you go ahead and like keep them at 45?
no, sir. But they would not be locked straight.
They would be out though.
They would be outreached, correct?
Okay, all right. So what you saw, I demonstrated, even though I used the term locked, and you're right, my elbows aren't quote locked, but they're straight out from me. So it'd be a straight up motion with your hands starting from your pockets, without bending your elbows, maybe not locked, but just picking straight up.
Not necessarily. I may pick her up from the side, I may pick her up from this side, I may pick her up from in front.
I'm talking about Mr. Reeves.
Sure, and he may have done the same thing.
Okay. Thank you for your time, Ms. Shaw. Thank you, Judge. I have nothing else.
We'll talk about the same time period the prosecutor was speaking to you about when he talked to you about sporting clays. That would be 2013, okay? Now, you were living, is it true that you were living with your father and mother at their house at that time?
Since April of 2013, yes, sir.
And so during that year, did you see your father having trouble or being slow when he first got up in the morning?
He gets up before everybody else typically. I mean, yes, I've seen him definitely slow down as far as his movements and slower to start. Even just getting up from watching a movie on TV, I've seen that, but maybe not necessarily first thing in the morning.
What about getting out of a chair? Does he pop right out, or does he use his hands to push himself up out of the chair?
He uses his hands and then takes a second to steady himself.
And that's in 2013.
Yes,
The same time that he's doing the sporting clays, he's having trouble getting out of the chair. Is that what you're saying?
You are
I don't-
asked and answered in this meeting.
Is that what you're telling us?
I don't know that it would be considered trouble getting out of a chair, but not with ease, for sure.
But you described that he had to use his hands. Did I understand you correctly?
Yes, sir.
And then you said once he gets up,
He takes a minute to steady himself.
so is it fair to say that his balance is off or not?
Yeah, I'm not
Maybe
gonna
at times.
object to that. It calls for speculation.
I'm gonna stay on that.
Have you observed your father being unsteady on his feet once he gets up out of the chair at any time?
The fact that he takes a second to steady himself, again, it's not something where I go, oh, his balance must be off, but I've observed that that could be the case.
And the time frame regarding trouble getting down on the floor to play with your daughter, that's in 2013?
Yes, sir.
Having his fingers freeze up, that's the same period of time?
Yes, sir.
Not being able to tie a shoe, is that the same period of time?
No, sir. That was a little bit later.
Thank you.
Anything further from this witness? May this witness be released.
Yes, Your Honor, we're going to reserve to keep her still on subpoena just in case we recall her.
Okay, and you have a way to do so. She's free to leave the courthouse if she wishes.
She is, Your Honor.
All right. Ms. Shaw, you're free to leave however you wish, but you are subject to recall.
Yes, sir.
Thank you.
Thank you.
All right, this will be kind of an overdue time to take a short 10-minute recess. We'll take 10 minutes and resume after that. Thank you.
All right.
be seated.